Okay, so we're ready to get going. Thanks everyone for being here today for day 3 of our PTAB program, our annual PTAB program. This is a CLE presentation, and the materials are linked to the panel URL. The title of the panel is After the PTAB Winning at the Federal Circuit. We're getting just a little bit of a late start, so we'll go a full hour so everybody can get a full 1 credit of CLE and keep everyone, including us, honest. So let me introduce the speakers, starting from the audience's left and moving to the right. We first have Tim Fink, and Tim is a partner at O'Melveny & Myers. And before joining O'Melveny, Tim served as Vice Chief Judge of the Patent Trial and Appeal Board at the USPTO. And O'Melveny's a sponsor. Tim has been a frequent speaker and very generous with his time over the years, and I really appreciate Tim. Thanks for being here. And Tim is also filling in for the new acting director, Coke Stewart. So thanks for doing that, Tim. Appreciate it. Next to Tim is Angela Oliver, and Angela is a partner with Haynes & Boone, and the focus of her practice is on appeals before the Federal Circuit, and she also does district court litigation and post-grant proceedings as well. Angela, thank you for being here, and you're filling in at the last minute too as well for one of your other partners who had was unable to make the trip. So thank you for being here, and also thank you for sponsoring as well. We greatly appreciate that. And last but not least is Kevin McNish, and Kevin is a managing member of the main law firm McNish LLC, and he's a registered patent attorney, and he represents clients in inter partes reviews and post-grant proceedings and ex parte reexaminations before the PTAB, and he also handles appeals before the Federal Circuit. And Kevin has been here in the audience many times. We appreciate you now agreeing to come and speak. You'll be speaking it live as well, and we really appreciate you being here, so thank you.
Thank you. Looking forward to it.
So what I'd like to do is I have no real preconceived notions exactly of what we'll talk about, so the conversation can go in any direction it wants to go in. Sometimes when we do these panels, they tend to take on a life of their own, and the focus becomes very specific. The overall question is what do you do after the PTAB when you're at the Federal Circuit, or maybe when you're considering going to the Federal Circuit, or maybe we could even talk about setting up the PTAB case because you know you're going to be at the Federal Circuit. But the topic is after the PTAB, and how do you hopefully win at the Federal Circuit? So with that being the big question, what's the first thing, Tim, that comes to mind that you'd like to share with the audience you think everybody needs to have front of mind before we dive in?
So we'll start at the beginning. The first thing you need to be concerned with is winning at the PTAB so that you're a appellee at the Federal Circuit and you have an 80% chance of being affirmed or something along those lines. So, and when you think about it, you want to make sure that as best you can, assuming that you have the winning case at the PTAB, you want to make sure that the PTAB decision is on all fours so that it becomes a substantial evidence situation on appeal, and your decision that the PTAB made is going to be durable and hold up on appeal.
Okay, great. And I'll come back to you maybe and ask you a little bit about actually making those decisions since you have some experience there. But Angela, your preliminary thoughts on this topic?
Yeah, I think that's certainly the best strategy, just win at the PTAB. But I think, related to that is you always want to have your appeal in mind from day one at the PTAB, whether you're a petitioner or the patent owner. Your initial briefing, the petitioner IPR petition or the patent owner response, those are your first big briefs that you're going to get put on the line for, what did you say in the petition, what did you say in the patent owner response, what arguments did you raise, what didn't you raise. So I think you just need to be thinking about developing your record thoroughly from the very beginning of the case and preserving issues along the way as they pop up. And I think that's something that, sometimes we see you get to the end of the case and you say, oh no, this thing went wrong. But then you look back and it's okay, well, we should have started trying to preserve this, earlier in the case. So just always kind of having an eye towards the appeal from the beginning on both sides, I think is really helpful.
Okay, great. There's a lot there. And
Yeah,
we could do a whole day just on
Absolutely.
that, but we'll come back to that and unpack that. But Kevin, your preliminary thoughts on this?
Yeah, so I want to echo what Angela said about prepping your proceeding, or prepping your record, prepping your evidence, prepping your arguments at the Patent Trial and Appeal Board with an appeal in mind. A lot of my practice is representing patent owners, and once trial's been instituted, whichever denominator you want to pick, the statistics are you're probably going to have a bad time in the final written decision once you've been instituted as a patent owner. And so that actually spurred one of the best pieces of advice I've gotten, which is write your patent owner response as if it's your opening brief at the Federal Circuit. So that means explicitly construe claim terms when it's going to be okay, run it by your district court litigators, of course. That means really tee up the legal issues as legal issues. Put yourself in a position where you can argue a claim construction issue on appeal as a claim construction issue, and not pulling an issue that would be otherwise reviewed for substantial evidence into a claim construction issue, because a lot of the judges are getting wise to that. They can see that folks are trying to pull these substantial evidence issues into claim construction issues when claim construction wasn't briefed as well at the PTAB. So all of that said, if you think you're going to be the appellant, and if you're a patent owner and trial's been instituted, you're probably going to be an appellant, frankly. Get those de novo issues papered up as best you can, and also get any miscellaneous requests for relief papered up as best you can. Trying to get discovery in, trying to get evidence in, bring court reporters to your conference calls so you've got those memorialized. All of that, just make sure you've papered everything up, and especially de novo related issues.
Okay, good. I mean, that's a great place to start. And if anybody has any questions as we're going through, please feel free to raise your hand. We'll get to as many questions as we can. And it does sound, in some level, in the first instance, a little bit weird to say just win at the PTAB and that's your best, but that is really your best strategy. And I think particularly patent owners, because a lot of the petitioners are repeat flyers at the PTAB, and they get it. But particularly if you're a new patent owner at the PTAB, maybe you have fallen to the misunderstanding that, well, if mistakes are made, they can be corrected later on. And the standard of review just does not allow for that to happen. And the one thing and we were talking about this the other day, Tim, with the standard of review, substantial evidence, for lay people or those new to what appeals are, it sounds like, oh, that has to be really robust evidence. And it's exactly the opposite. It's absolutely anything that could remotely support the decision, and it's going to be affirmed. So what kind of conversation do you think you need to have? Let's say that with those new to the PTAB, startup companies, maybe they're facing the PTAB for the first time. Well, how do you get this across? Do they really get it?
I think it kind of goes to something you said, or Kevin said, about the not being, so if you're not a frequent flyer there, maybe not considering the best way to position the argument for an appeal. So the best example I can think of is patent owners frequently don't want to do any claim construction. Petitioners often don't either, or then they're trying to kind of keep their options open, I'll say. But if you have a good claim construction argument as a patent owner, it could be a good way to get an appealable issue dealt with, in the first instance by the PTAB. Okay, and then if you still lose, you have a de novo review on claim construction rather than a panel of Federal Circuit judges asking you, why didn't you bring this up as a claim construction earlier in the case, or any point during the case, and instead of arguing it as sort of a fact issue which could be affirmed on substantial evidence, which is a scintilla of evidence.
So let me ask you that. I mean, and I guess maybe I didn't appreciate, this has come up throughout the last day and a half over and over again about the claim construction. How does any of this happen at the PTAB without a claim construction? Because, and I realize Judge Rich was talking about something slightly different than the PTAB, but when he said the name of the game is the claim, I mean, that resonates to me throughout, whether it's prosecution or litigation or licensing or M&A due diligence or whatever. You got to know what the property right is. How mechanically, how does a PTAB case go without the judges doing a claim construction?
I think it's a little bit different than district court, where you have a hearing, and you often are doing claim construction outside the context of, at least for the judge who is making the determination, the judge isn't generally aware of, this is what the infringement arguments are, this is what the invalidity arguments are, and so court sort of doing a claim construction in a bit of a vacuum. At the PTAB, the approach that is normally taken is, if the argument seems to be something that goes to, and this is going to be funny, but it's plain and ordinary meaning,
Mm-hmm.
and no, this just, an apple is not an orange, everybody knows that, then, that's a fact issue, and you don't need to construe the claim. And if the parties don't argue it as a claim construction, in many cases, unless the PTAB feels that they need to do a claim construction, they won't do it either. So, what they'll say is, there's a line that'll be in the decision, we don't see a need to construe claims at this time, citing a case called NIDEC, I think.
Yeah.
And you see that.
You see that all the time.
Right.
Yeah.
So if the parties don't want to do claim construction, we don't need to do claim construction. And if you think about it, in a district court, you could have a whole patent go through a trial with no terms in dispute.
Or maybe only 2 or 3 that are really argued.
Sometimes none.
Yeah.
Sometimes they're all dropped before Markman.
Mm-hmm.
And the parties, if it comes up during the trial, it can kind of do an O2 micro kind of objection and say, okay, we need to construe the claim. But it's the same thing. If the parties aren't making it a dispute, the judges often won't decide it as a claim construction issue.
Uh-huh. And Kevin, well, let me ask Kevin, because you brought this up. Do you think it's a mistake for for either side, but you represent primarily patent owners, did you say?
I switch hit, yeah. But I do a lot of, most of my appellate work is patent owner side.
Okay, so let's talk about, do you think it's a mistake from the patent owner's perspective to not go down the claim construction path? Maybe I'll ask you, Angela, the opposite. Is it a mistake for the petitioner? I mean, is there a benefit somewhere on one side or the other, or do you think it's a missed opportunity, or?
So I think more often than not, patent owners are best served by making explicit claim construction arguments and making those very clear on the record. And I know that's a little bit counterintuitive from conventional wisdom for prosecution, right? Mm-hmm. Because you want to say as little as possible. You don't want to create file history estoppels. And it's a little non-intuitive sometimes to district court litigators, because they fear that's going to get thrown back at them in litigation. But you as patent owners counsel have a duty to, in my opinion, know that your plaintiffs, your district court plaintiffs, infringement contentions as well as you can. Certainly from the complaint, it's publicly available. If there's publicly available contentions that you can rely on. And if you can craft a construction that's supported by the intrinsic record and consistent with the contentions and distinguishes you over the prior art, you need to do that, and you need to explicitly construe the claims in that fashion. Okay. And I think if you don't, you're going to find yourself trapped in substantial evidence land on appeal.
All right, we're going to dive more into this, but I want to get Angela's thoughts here.
Yeah.
And feel free to respond to anything that they've said so far, but I would like to hear your position on, is it a mistake or is it strategically a good choice for petitioners not to force a claim construction issue?
Yeah, so sometimes I think on the petitioner side, and I work on both sides too, but as a petitioner, I think sometimes you don't know that there's a claim construction dispute until you see the patent owner response. Mm-hmm. And so, truly there may not be an opportunity in your petition to flag the dispute. But by the time of your reply, if there is a claim construction dispute, I think you need to engage. I think a lot of the times what we'll see is petitioners will just say, well, even under that construction, the art teaches it. That's good, but I think also engaging in the express claim construction discussion is important too, at which point you are providing a construction usually, or at least you're making your position very clear. I do think, going back to your earlier question about district court and how it works procedurally at the PTAB, it's tough at the PTAB just the way it's procedurally set up. District court, there's so much more flexibility, because you have the Markman hearing early, and then most district courts, the local rules allow you to actually amend your contentions on either side within 30 days after you see the Markman order, because you, like you said, the name of the game is the claim, right? You can kind of like adjust, like, okay, now we know here's the bounds. How do we go forward with our evidence? And then, like Tim mentioned, even during trial, right? Like, if there's a dispute coming up, you see an O2 micro issue. It's one. When I clerked in district court, that was like one of the scariest things. Was like, oh no, we feel like an O2 micro issue is brewing. Like, now we're gonna have to stop and do claim construction. But at least the parties have a chance, even mid-trial, to adjust their evidence, with their witnesses and what's going on, to try to make sure they are addressing the scope of the claim. And in the PTAB, I think that's harder because it's just not kind of set up for that. By the time you get like a final ruling on claim construction, it's often the final written decision, and then no one's changing their evidence at that point.
At that point, it's,
I do think maybe that's an area for consideration of like, should we tweak the procedures? I don't know. It's just much harder.
So, Tim, did you want to say something before?
Yeah, I mean, I can tell you it's hard from the PTAB point of view, and I certainly don't think it would be shocking to hear that it's been suggested and considered many times. Why doesn't PTAB do a Markman hearing or a mini Markman or something? And it's hard with the procedural schedule and the briefing in place to cram a sort of a full-blown or even a partially blown claim construction hearing into that.
And it sounds like the parties don't usually want it either.
And that's often the case as well. So,
and that's where I want to go next.
So,
go ahead.
Yeah, what I would say is, so I typically probably 80% of the cases I work on, we're also representing the party in district court. So I work.
What percentage?
Probably 80%.
Okay.
So,
because that's where we spent a little time talking about that yesterday about the streamline. That's where we want to go with the conversation. So.
Yeah. So I mean, so if a party hires us to do district court litigation, often we're also doing the PTAB component of it, and so this is really efficient from our point of view because I can pick up the phone anytime I want and say, hey, infringement team, non-infringement team, whatever you are, how's this looking? I can kind of get a feel for how the arguments are evolving, and so I have an idea of where the fault lines are in the case between making an invalidity case at the PTAB or a validity case and the flip side on the district court, and kind of keep that conversation going in real time. And because of the timing, I mean, if you're in East Texas, often your petitioning and your claim construction disclosures are sort of happening almost in parallel, or maybe you file a petition and in the meantime, you have the patent local rule, was it 4.2, 4.1, 4.2, or the claim construction, what terms do we want, what are the proposed constructions? So that's sort of evolving in parallel, and so it's tricky. It's harder when, I think, and Kevin brought up the example of you have fewer touch points if you're not coordinating closely with a litigation team on the PTAB side, and if you have fewer touch points, or it's a little bit more arm's length, and the other aspect of it is that when you're bifurcating and you have a PTAB attorney and a different district court attorney, their interests aren't perfectly aligned, right? I mean, the PTAB attorney is hired to win at the PTAB, the district court is hired to win at the district court. When you're both in the same place, then your interest is to whatever is best for the client. And
that's where I want to go with the conversation, dive in a little bit deeper, because it picks up on a thread that we talked about a little bit yesterday. But there's this, and I believe it was Bill Parcells who famously said, if you have two quarterbacks, that means you don't have one. So that means neither person is good enough to be the quarterback. And that analogy, I think, kind of to some extent applies here in two different scenarios. One is, if I were a patent owner, chief IP counsel, and I was facing this, I would almost mandate that you had the same firm involved in the litigation or at the minimum that what you had was you had identified who's in charge. So if you have multiple teams, because you have people have unique expertise on, so you want to pull it all together. You got to identify, okay, this is the quarterback, this is the person who's going to make the strategic decisions, and then the rest of you have to kind of implement that. Because it seems to me that that's a big part of the problem. The other thing that I think that is problematic is when you don't have, and this maybe is a function of that, is you don't have a real theory of the case. So like I always used to, I just laugh in law school, we're none of us are doing criminal law right now, but it's like I didn't do it. And it's like, okay, well, I wasn't there. Well, if I was there, then and I did it, I didn't intend to do it. Or if I was there and I did it and I intended to do it, it was self-defense, and it's like, okay, pick a lane, pal.
Pick a theory. Right.
Pick a theory.
Right.
And I do think a lot of times with in this space, because of the difference between winning in district court and then winning at the PTAB, you get people who don't pick a theory, or they wind up trying to weave this theory that's like too smart by half, and neither one makes sense. And it feels to me like, you remember the movie Men in Black, where Vincent D'Onofrio, he was coming out of his skin, the alien, he couldn't keep the alien in the human skin. I feel like sometimes that's the arguments that you get, because it's like, come on, pal, there's a winning argument here, and that ain't it. Yeah. But, maybe you can't make the winning argument because people on the district court side have already filed something, it's too far down the road, or what have you. But I think having a streamlined view facilitates not only winning, but I think it also makes the case easier for the federal circuit, right? I mean, there is a story rather than multiple stories. Kevin.
Yeah, so I want to push back on your two quarterbacks analogy, and I'll be the first to tell you I'm completely biased in this because I'm always separate PTAB counsel. I don't do district court litigation. I think that is actually a misconception of PTAB counsel's notion that they're a quarterback. And I think you should not think of yourself as a quarterback as a PTAB litigator, especially if you're patent owner side. You need to think of yourself as somebody on the offensive line or a fullback, somebody who's blocking up so that the real quarterbacks, the people running the proceeding where money does change hands, the district court litigation, can run the play effectively. So when I practice, I treat my district court litigators as if they're a client just as much as I treat the actual client as a client. And I think if you're separate PTAB counsel, you really need to do that. You really need to stay closely entwined with your district court litigation counsel, because exactly what you pointed out, things will be difficult for you at the PTAB, they'll be difficult for you at the district court, and they'll be difficult for you at the federal circuit and appeals from either of those proceedings.
So let me ask you, I mean, you've been here the last day and a half, so you heard what Scott was saying yesterday about how sometimes he didn't name any names, but sometimes he's had situations where the district court counsel comes in and says, okay, you need to win this. You need to be making 102 arguments here. And it's like, well, it's not 102. It's not the same, and on the petitioner side. And he's like, well, it has to be, because we've already gone down that path and we're making those arguments in district court. And it's like, well, it would be 103, but it's just not 102. And he gets kind of sometimes forced into making these arguments that aren't going to prevail. I mean, how do you deal with that? How do you stay on the same page?
So I think for that specific example, you can almost sidestep that and say, look, anticipation is the epitome of obviousness. It's being run as anticipation of the litigation. Maybe I'm running single reference obviousness, or obviousness with two references in at the PTAB. And maybe I'm not expressly stating that a reference is lacking a particular feature when I'm making these combinations in the petition, but that particular example doesn't really spike my blood pressure the way that disputes over indefiniteness can. And that's something where people can get into trouble very quickly at the PTAB if, for instance, they've got some claims they're challenging at the PTAB. They have not said anything about whether they're means plus function claims. And in the district court litigation, the litigators have said these are means plus function claims and they're indefinite for lack of corresponding structure. You've got to stay on the same page with that, because otherwise, the PTAB will say, well, look, your district court litigators are saying these are indefinite for lack of structure. You didn't say anything about these. have you met your duty of candor, petitioner's counsel? And this happens. This happened several times a few years ago. So that coordination on indefiniteness, I think, is kind of the most key issue. Some of the 102, 103 stuff you can massage a little bit. That's one you can't, especially when there's irreconcilable inconsistencies between the indefiniteness and the 102, 103.
Tim, you were, when indefiniteness came up, you perked up.
Oh, it happens all the time. I mean, the means plus function context is probably the most acute situation, because you got a district court person telling you, hey, it's means plus function, we've got to get means plus function. And by the way, it's indefinite because there's no structure, under, aristocrat and progeny. And then you got the PTAB, okay, but that's going to be a loser at the PTAB because they don't do indefiniteness. And by the way, I don't really think it is a means plus function. And that's where it comes, like, if your litigation team and your PTAB team are aligned, they can kind of pick the lane.
Right.
If you're not, then the client has to pick the lane. So I do have one major client that bifurcates. That client is on the phone with both teams. Both teams will be there every week, and that client knows all the theories of the case, and that client will pick. Recently, they picked against my advice and went with the district court, and they got an adverse decision from the PTAB, and they said, that's okay. We picked our lane, and you did what you were supposed to do. You did what we asked. But indefiniteness is definitely like one of the big fault lines, because it's hard to reconcile that.
And we don't necessarily need to make this an indefinite panel, but I just have always had problems with the idea that you're saying that the claim is indefinite, and then you're going and you're in the same form sometimes, or in the alternate form of the PTAB, you're saying, well, this claim means this, and this prior art reads on that claim. And it's like, well, if you know what the claim means, and if you know this prior art reads on that claim, it always struck me as well, it can't be too indefinite, and I get that there is some play there, right? Like, okay, so whatever this, because sometimes it's like, well, whatever this means, it has to mean something in this box, and that reference covers it, or this combination covers it. Yeah. But sometimes in the closer cases, it's like I see people make very specific arguments about what the claim means, and then somewhere else they're trying to say, well, I don't even know what it covers. It strikes me as you can't have both.
If you're going to do that, the only way to do it is to say, look, I don't know the metes and bounds of the claim. It could be I could go on forever, but I do know it means at least this. Mm-hmm. And if you have that argument, because if you think about it, that's sort of how the examiners can do a art rejection and an indefiniteness rejection in the same rejection, right, in compact prosecution, and the way they can do it. And often it'll be appealed to the PTAB in an ex parte appeal. And I forget the name of the case, but Jay or Mike or Grace could I'm sure tell me. If you can apply the art to the claim, then you still do. But you could still say it's indefinite because I just don't know what else could fall within the scope of this claim.
Right.
So that's the only way it seems to me to reconcile it, and that will work if it's credible.
Yeah. And just building on what Tim said, one of the things I like to do is when there's a claim term that I think might be indefinite, but there's an example in the specification that says, hey, this falls under this claim term, I'll look for prior art that has that claim term, that teaches that example identified as being within the scope of that claim term. And another side benefit of that is it can often head off any claim construction disputes the patent owner wants to raise over the scope of that term, because it essentially leaves them with arguing that the claim term doesn't cover an expressly disclosed embodiment as being within the scope of that term, which helps you get to substantial evidence land as a petitioner.
Okay. All right, we can come back to this if we have time or any other questions, but Angela, there's something you raised when I think at the very beginning about preserving issues, and what problems do you see with preserving issues on either side, one side or the other, or things like when you're looking at this, you're like, I wish they had done this and maybe preserved it better, or so, and I don't know that we're talking about waiver arguments and that sort of thing, but and maybe we are, maybe sometimes at the PTAB it's just not even raised, so the Federal Circuit's not going to consider it. But there's also this idea that, well, you really just did a lot of hand waving about that at the PTAB, and we're, as the Federal Circuit, not going to really peel back the layers of that onion if it didn't matter enough for you to do more about it at the PTAB. So what issues do you think people should be making sure they focus on and preserving and making better arguments about?
Yeah, so I think like the last thing you said there about like the Federal Circuit's not going to look at it if you didn't bother to do more at the PTAB. I think that's like an important point, because one thing we've been seeing in some of the Federal Circuit decisions is, you know, a lot of the times people argue on both sides of the case, petitioners and patent owners, when they've lost at the PTAB, they say, well, the other side raised an improper new argument, either in the reply or in the surreply, you know, improper new argument, we didn't have a chance to do evidence or respond or whatever. That's a very common argument, and we've seen that for, you know, a decade now. But you know, I feel like there was an era at the Federal Circuit where those arguments were working a little better, kind of early, maybe 2017, like that era. I think more recently what we've been seeing is the Federal Circuit saying, what did you try to do at the PTAB to fix this problem? Did you file a motion to strike, which the PTAB rules allow? And they say, you know, if there's an improper argument, you should file a motion to strike. Did you file that? Did you ask permission to file that? Did you ask to try to submit new evidence? Did you ask to try to submit a brief to respond to whatever you thought you needed to say more about? And usually the answer is no, because historically that's not been like a particularly prevalent practice at the PTAB. But now the Federal Circuit, in a number of decisions, has said, you know, if you didn't ask the PTAB for help to try to fix it, we're not going to try to fix it. We're not going to go and like be like, oh, we need to fix this. Not always, but I've seen the Federal Circuit do that a few times recently. So that's something to think about procedurally. If you think something's going unfairly, if you think you need to add new evidence, if you think you want more briefing, ask, right? And then if the PTAB says no, then, you know, you can ask the Federal Circuit, hey, they should have let me.
Right.
And do you think it's also something, I see it in every brief. If I'm the petitioner and I want, it's petitioner raised new argument, it's in every brief. Like even, it's like, well, anytime you say something different in the reply than what was in the petition, you get this new argument idea. And if you're going to say that every time, then the Federal Circuit's not going to take you seriously. The PTAB's not going to take you seriously, and the Federal Circuit's not going to take you seriously, right? I mean, it just seems like the kind of thing I see every time.
Yeah, and I mean also as a patent owner or a petitioner, you have to keep in mind that what the Federal Circuit considers an impermissible new argument has narrowed in scope pretty considerably. For example, analogous art. The petitioner can argue that for the first time in reply, and they can raise prongs that was not present in their petition. You know, claim construction issues. You know, petitioners can put in new evidence in their reply in support of a claim construction or to address a claim construction that they may not have previously presented. And so, you know, as a patent owner, you really need to identify a new direction that the case has gone that was not prompted by the patent owner response. And if you don't have that, I would say save your breath on the new argument. Maybe try to ask to put in new evidence to rebut this if you think it's damaging enough to your case. But I think arguing that as an impermissible new argument is going to cost you credibility, both with the board and the Federal Circuit.
I almost liken it to like a new ground of rejection at the patent office. It's like, you know, what is the thrust of the argument? If it's really, you know, taking a 45-degree turn or 90-degree turn, you know, that's probably something that would be a new grounds of rejection. But
Right. If not, yeah, these things get argued, I think, too much, and they're. I'm not going to say frivolous, but they're not calculated to succeed. And I also think, to pick up on another topic that came up at least a little bit yesterday, is, but we should probably hit much harder here, raising too many arguments just dilutes the good ones. And I see that, you know, a lot. I mean, can you talk about that? Maybe Angela, will start with you this time.
Yeah, sure. I will say, like, from the appellate side, although this goes for patent owner response too, I really liked your comment earlier, like write your patent owner response as if it's your opening brief. As the appellant at the Federal Circuit, I think you really need to be strategic about which issues you raise. And I would say 3 is generally the max, and even that's a lot. So if you can hit 1, maybe 2 issues that are really strong, hopefully with a good standard of review, I think that's going to be much more effective, because once you get to the kitchen sink approach, I mean, it's just too much. Like, the court reasonably cannot go into the level of depth that they need to flip on an issue when you've raised 16 issues.
Right. Kevin?
Yeah, I agree with everything Angela said there. It's you as the appellant, you have to be very, very tight. 3 issues max. I completely agree with that. And oftentimes I try to go just to 2, which is the de novo issue, and then the 102, 103 issue that depends on the de novo issue. So it's almost 1.5, 1.25. I don't know what you call that, but so much of being able to have that and have that preserved is just making sure you're in position and you've papered up the arguments at the PTAB. The other thing is, oftentimes we'll see process arguments, some kind of APA violation. Make sure you can actually show prejudice from whatever APA violation you're alleging in your opening brief, because if it's just, my procedural rights weren't vindicated or weren't respected, and you don't have any way to show that it would have made a difference if, say, this evidence had been considered or this evidence had been, you've been permitted to submit this evidence, maybe leave that one out, because, some kind of alleged defect in process without actual prejudice, again, you're wasting the court's time, and it's going to cost you some credibility.
And I'll say, going back to your multiple quarterbacks discussion earlier, this is a hard one, because as appellate counsel, first of all, you really do need to be in control of what's in the brief. You can't necessarily just, but you have to give strong recommendations about, we're going to have to give up X argument, whatever it is. And sometimes, district court counsel loves some argument, or sometimes, the client loves this argument or that argument, and they feel like it was really decided wrongly. But if it's just a fact issue and you have some other better issues, you have to be able to say, we have to give this argument up. It's not going to work. I know we all loved this argument, but it didn't work at the PTAB, and now it's not going to work on appeal.
Yeah, I almost think, and this has come up a few times lately, I think I need to get like some psychologist to join us sometime, because on these panels, because there's got to be some, and it's not a psychosis, but there's got to be some kind of description as to why do people cling on to things that just have, like 99 out of 100 of us would look at that and say, this has no chance, but they're just so convinced. Yeah. And it's like, and then maybe if I just say the same thing over again, but the second time I say it louder, or maybe the third time if I bang on the table, and it's just, I don't get it. I mean,
I was in a hearing in the fall, in a federal circuit hearing, and the presiding judge told you could see the argument was losing. It was a forfeiture argument, and you could see it was losing. And finally, the presiding judge, I won't name it, said, you probably want to move on to your next argument.
Yeah, that's a bad fact when that happens. Yeah.
But I think that raises an important point where, and also building on Angela's comment, when you're selecting these issues, these arguments you're going to make, that's not just a one-time process. You're actually iterating that during the scope of the appeal. Maybe when one of the subsequent briefs come out, you start thinking differently about the argument, especially when you're doing moots before you go into your argument. Maybe an argument you thought sounded great in the brief is now very tough to defend on oral argument, and you want to focus on one of your other issues that's a little more oral argument friendly, because, it's the either way, you're only getting 15 minutes up there, and that 15 minutes goes very, very fast, whichever side you're on. Mm-hmm. You may find yourself in a position where you think you've got a good issue, but it's going to eat your entire time, and you may have an issue you can explain more concisely and more effectively, and may want to lead with that, and maybe even rest on the papers on the previous argument.
Yeah, and that's, I just was looking at one of the articles that we have for CLE materials. It is an article that Coke Stewart wrote a little while ago after we did a panel like this, not about PTAB, but just, generally speaking, winning at the federal circuit. And 2 of the suggestions from one of them is write the shortest brief you can. And then another one is present the shortest argument that you can. And I think I see all too often people, lawyers, just filling up the space in the brief. Just because you get 50 pages doesn't mean you need 50 pages. And if you have 25 pages, we're going to want 26. If you get 50 pages, we're going to want 51. And a lot of times I think the best argument is the one that is no longer than it needs to be. And I think a lot of times disservice is done by just filling up space. Thoughts on that? I mean, how do you make sure that everything that you put in there is persuasive? Because that's the name of the game. It's just persuade. And you're not getting paid by the word. So it's not like you have to go to the last line of the page. play with fonts, and then run the risk of gaining the ire of the court. But
Yeah, I'll say, Brian Garner says it's best to try to hit your brief at half of the word count. So Fed Circuit's 14K, he would suggest 7K, which that's pretty tough. I think maybe I've done that once.
yeah, going that narrow is pretty tough.
Yeah, but I think it's the right sentiment, right? I mean, it's tough, like when you're on the court side, and Tim can speak to this obviously. But like when I was clerking, I would have a stack of briefs this big to read for the next panel. When you're on page 35 and you're still in the statement of the case, it's really draining.
Right. Right.
And I just think a lot of the times what people are filling it with, particularly from PTAB proceedings where we have so many 103 arguments and things, you'll just see pages and pages of platitudes about KSR, like general statement about here's how obvious works, and like 50 of them, and it's like that is not helpful. The court
they
knows
get
that
that.
stuff. Yeah, they know it like the
Yeah.
back of their hand. What you really need is one or two cases that are factually helpful, and you can go into detail and say here's why this case is like that one. All the platitudes just waste space.
Right.
Yeah.
Kevin?
Well, Angela, can I actually ask you, as since you're someone who did clerk and mentioned statements of the case, what do you find to be statements of the case? I think are kind of underutilized effectively. I think people don't always use them effectively. What are some effective statements of the case you've seen, and what are some best practices you can glean from that?
Yeah, so I think it depends on the types of arguments that you're raising, but generally I think shorter is helpful as long as you get the right content in there. Not argumentative. I think when you start including your arguments and saying this wasn't raised, all of this stuff in the statement of case, it kind of irks the reader because that's what the argument section's for. But some effective things are if you do have, for example, some sort of procedural argument, a waiver argument that you're going to raise in the argument section, then it is helpful to include kind of the flow of how things went in the statement of case. Here's what was argued in the patent owner response. Here's what was argued in the reply. Same thing with you've got like a claim construction issue that it was maybe an implicit claim construction at the board, but now it's turned into claim construction on appeal. Going through how that developed at the board, that's very helpful. But as far as just talking about like, everyone raised this factual argument and this factual argument, I think sometimes people go way overboard in how much they explain there when you're just going to have to reiterate the same thing in the argument section.
So what is your view on the summary of the argument? I mean, I think a lot of times attorneys don't spend enough time looking at the brief as a persuasive document. And some of the ones that I have read that I find just the most persuasive have the shortest argument sections, but they explain things very well, and it's easy to read. It's not dense, it's not, but what say you all? Tim, maybe we'll start with you. I mean,
it's really, I try to resist the urge to write those kinds of things first, or say like, let's write the actual argument first, then let's go back and figure out what we want to say in the, in the summary or the statement up front, because honestly, I read a brief recently where I was still reading the statement of the case, and I was more than 50% of the way through the brief. And then I turned in and it said argument. I had forgotten that I hadn't gotten to argument yet. And I thought, oh, here, let's start over again and
Yeah.
argue it again. It's almost like two briefs. So I think one way to avoid that is to, picking up on these examples that Angela and Kevin gave, is to do your argument, play it all out and see what things you can cut and which things work for you, and then go back and do that. I don't know if that answers your question, but I think...
Yeah, no, I mean, it does in a lot of ways. I mean, because I think it'd be a huge mistake if you're halfway through the brief and you're still on the statement of the case. I mean, I think the statement of the case needs to be, if it's not, going back to if you have two quarterbacks, you don't have one, if the statement of the case takes you half of the brief, then you really don't have a theory, right? Because I don't have to go and explain everything that happened in this case. What I need to do is I need to persuade you that I'm correct on whatever I'm raising. And there will be, and if you have a statement of the case that's that long, you're burying the things that matter the most to your narrative for the argument in this just, Moby Dick sized that nobody's going to read it. And am I wrong, or you agree, Kevin? What do you think?
Yeah, I mean, when I sit down to write a statement of the case, the first thing I start thinking about is the procedural history, and it really needs to be just as for me, as an appellant, it's just a roadmap of where I made arguments to the PTAB, and just to show the court, like, hey, I preserved everything.
Yep.
Here's where it is in my patent owner response. Here's where it is in my SIR reply. Here's where it is in my an oral argument. And it really shouldn't be anything more than that, unless, as Angela mentioned, you've got some procedural issues.
Nothing extraneous, right? I mean, it's the,
Yeah, it's if it doesn't belong there, take it off the plate.
If it doesn't help your argument or serve a purpose, why is it there?
Yeah, so I mean, I mostly use the procedural part of it just to show, hey, I'm the appellant, I've preserved the issues, I'm not trying to pull one over on you by raising something for the first time now. Turning to the...
And that makes a lot of sense. And you would probably also use that for if you were going to make the argument that, well, we asked at the PTAB, and so this isn't the first time. Maybe the first time there's any paper filed on it because they wouldn't let us file the paper.
Yeah.
So that would be important. You'd have to mention that.
Sure.
Yeah, and
So non-events can matter.
exactly. But one of the things you do need to do is paper up those non-events at the PTAB. One of the most challenging issues is maybe you got denied authorization for something, and there's not a separate order memorializing it, which has happened in the past, or there's not any kind of record of what you actually argued on the conference call and how you argued it and how you preserved your arguments on the conference call. And if there's no written record of that, if there's no court report or transcript you can put into the appendix, you're going to have a bad time preserving that argument at the federal circuit. So it's not just substantive preservation, it's also preserving it on paper.
So I really like that, and I think that's a great idea. Don, is that something that you need to file at the PTAB so it's a part of the official record, or is it just something you keep as a part of your file so that then when you're on appeal, you can add it to the appendix in the federal circuit?
No, it's something you'll usually be ordered to file. Really best practices, if you're bringing a court reporter, notify the board, notify the other side, and then the board will usually say, hey, we'll enter an appropriate order. Party who brought the court reporter, please file a transcript as your next exhibit.
Okay.
if it's done by email, which it can often be done at the PTAB by a joint request of the parties, hopefully they follow the procedure and they both file, or one party files a non-argumentative request for a paper or something to brief something, and if the PTAB says no, we don't think it's necessary, that, and you might get that by email, you can request the board to enter it as an exhibit and say, very nicely, the parties do not object if request, because you can't file exhibits, anytime you want at the PTAB. It has to be, on certain events. But like if you had something and said, okay, well, you denied my request, may I put it in the record? And I think the answer is always going to be yes. Go ahead and put it in the record.
Yeah.
The panels will often just do it themselves too. They'll often say, we denied the request and we entered it as exhibit 3001 or something like that.
Right. Kevin, did you want to say?
Oh, no, I had nothing to add to that. It's just, one challenge I've occasionally faced is, without tipping the line into argumentation in my email requesting authorization to do X, Y, or Z, is, revealing why I want this and the reasoning for that, so I've got a clear record for it. So sometimes I'll say, and I usually will almost never go beyond this, party I represent requests X, they request it for this reason, and just leave it at that. And I think if you go anything beyond those two sentences, then I think you're starting to veer into argumentation, but make sure the reasoning for your requests in a sentence, and oftentimes, if you can't articulate the reasoning for your request in less than in a sentence, maybe you don't have a good basis for that request.
And
And it is argumentative.
Yeah.
I would say if you always are supposed to confer with the other side before you send this to the board, and often they'll say, okay, well, if you're going to say that, I just want a sentence to say this.
Yeah.
And usually you can kind of negotiate it down to, this is a petitioner's petition, this is patent owner's petition, petitioner respectfully requests a brief or a conference call, and patent owner opposes the request, the parties are available at this time. And if that's the way things should work, it's often a lot of work to get to that nice email that's non-argumentative, but I think it's the right way from the judge's point of view. That you think about it more like district court. Don't be sending me emails with arguments in it. I don't want no briefing by email.
Yeah.
Right. Right.
Mm-hmm.
So we've talked about preserving the issues here, but like generally speaking, we kind of talked about it generally, how you do. Specifically, are there any issues that you think that either patent owner or challenger too often don't develop enough, so that when you're actually looking at the record and you're up on appeal, you're like, damn, I wish they would do more here, and they, for whatever reason, don't ever seem to do more there. Is there something, I guess, that gets short shrift too often?
I would say claim construction by patent owners, and oftentimes what will happen is you'll see a patent owner response. It'll distinguish over the prior art by saying, well, this prior art doesn't teach this limitation. That then the patent owner, then realizing they're facing the substantial evidence standard of review on appeal for whether a reference teaches a limitation, suddenly morphs that into a claim construction argument and is raising a whole bunch of intrinsic evidence and pointing things in the spec and the file history and the claim language, et cetera, et cetera. And the Federal Circuit judges have kind of lost patience with that. I think they really do want to see parties develop the claim constructions explicitly in their papers at the PTAB. And sure, they'll let you put in new intrinsic evidence that was previously in the record at the PTAB on appeal, right? Cite additional portions of the spec, cite additional portions of the file history, because they can, review all that de novo. But when it comes to trying to convert a reference doesn't teach a limitation argument into a claim construction argument on appeal, I would not recommend trying that these days. I think the climate has gotten a lot more hostile to that, and I think you really should be papering up your claim construction argument explicitly in your briefing at the PTAB.
Okay. Angela, is there anything that comes to mind that you see?
I would say, continuing on that, on the petitioner side in the reply, dealing with claim construction more expressly and not just arguing that even under that construction it teaches, that's good to have that fallback, but also directly addressing the claim construction dispute and clarifying your own position if needed, because, and this goes actually for patent owners in this reply too, right? They can also raise the dual argument of, well, even under whatever construction, it doesn't teach this thing. Because, having those two options gives the board the opportunity to make two independent rulings, right? And insulate its own decision, by saying, here's the claim construction ruling, but either way, we would rule the same under either, whatever. Which then makes it, from the board's perspective, I think difficult for anyone to appeal.
I think it could be as simple as saying, patent owner says this doesn't teach because this isn't what the claim covers. We disagree because the specification says this, and this is what, I mean, it could be as simple as a couple of sentences, I think, if you have a good rebuttal to that, mm-hmm. and say, no, they're trying to import, a negative limitation to the claim, the specification says this, and there's another example, and I think at that point you've sort of preserved it, haven't you? I mean, it doesn't need to be broken out and made into a Markman presentation. It just needs to be.
It needs to be there.
Be there as claim construction,
yeah.
not as, don't hide the ball.
Well, the thing that would, I think, irritate me if I were a judge, and I get sometimes it is the right thing to say that regardless of whatever claim construction you come up with, or this art applies. I think that gets used too often, because it feels to me like what you're doing is you're inviting the court to do the heavy lifting to figure out, well, what does it really mean? Where are the boundaries? Where are the line? And you as the advocate, that's your job to help them come to your position and understand where that is and not leave them to their own devices. And I wonder, is that because you want to save words for some other area that may, but it seems to me that that's just a critical area. You got to have a theory of what does this mean and why is this prior art really on all fours, whether it's anticipation, probably not. What's obviousness, when you put these together, you get it. I just think it misses an opportunity, both from the petitioner and the patent owner.
I think that's right. I mean, if it's a winning claim construction issue, either because it's somebody's going too narrow or somebody's going too broad, whatever, and that's the way it's kind of developing in the papers, then I think you have to say that and say this is what they're trying to do and this isn't right because that's not consistent with plain and ordinary meaning, the specification and the intrinsic evidence. And by the way, I anticipated they were going to go there, and that's why I added another reference. That's why my ground 2 has another reference, so that I kind of have, I'm not trying to stretch something too far. That way, and then you have the kind of the backup, which is, look, it would still be obvious anyway if you're a petitioner, because those are the kind of things you have to really anticipate, I think, because you can't add any. You pretty much, your theory of the case as petitioner has to be pretty much in the petition.
Yeah.
Yeah.
So we've been talking a lot about the writing and being persuasive on the paper and making sure you've papered it up so you can appeal. How important is the oral argument in these cases at the federal circuit? Do people spend enough time caring about them? Does it not really even matter? Is it all about the paper? What do you think, Kevin?
So I think I'd adhere to the conventional wisdom that you're not necessarily going to win a case at oral argument, but there are many ways you can lose a case at oral argument. One issue I have seen sometimes with less experienced advocates at the federal circuit is they think they're in front of a jury and they're trying to first tell the court about how great their patent is and what a breakthrough invention this was, and the court just doesn't want to hear that, right? It needs to be like, hey, what's wrong with the PTAB's decision and why does that make a difference under the relevant standard of review? So listen to, I would say, listen to oral arguments before going up. Especially if if the oral arguments for cases that are cited in your briefs, so you can be ready for some of the questions that are coming up. And just remember, it's about, at the federal circuit, if you're the appellant, it's about what the PTAB may not have gotten correct. If you're the appellee, it's what they did get correct. It's not anything about who's the good guy, who's the bad guy. Is this a breakthrough invention? Is this patent not worth the paper it's printed on? Stay focused.
Okay.
I think, the way I think about it, and my experience is much more with the PTAB than the federal circuit, but I've done both, is whether you're when you're in front of the judge, your oral argument is supposed to be like a conversation, right? And if you try to keep reminding yourself that you're not here to pound the table and no, Your Honor, really it is waiver, and you read the room. If it's not working and they're not, either you can tell, right? If you so move on, okay, I can see this isn't resonating with you. I wouldn't say that, but right.
Yeah, no, yeah, that's absolutely
they're just
right.
trying to get to what's the best way for me to resolve this appeal.
Yeah. I think the goal should be to win your case on the briefs. You really need to spend the time and go deep on your briefs, because that's where the court spends most of their time prepping the case, right? They're studying your briefs, the clerks are writing their memos based on the briefs. And so there's a lot of thought that goes into the case way before you ever show up for oral argument. And so, like Kevin said, by the time you get to oral argument, you're probably not going to suddenly win your case at that point, but you could mess things up. And I would say, look at the room, figure out what's happening. You don't have to use all of your time, like you said earlier, particularly as the appellee. If you're not getting questions after a couple minutes, it's a good indication that you probably don't want to use all your 15 minutes. They probably would like you to sit down. And I have many times.
Yeah.
I've sat down after 4 minutes, after 7 minutes, depending on the case. So it's the court's opportunity to ask what they want to know from you, to answer their questions, to ask questions that will help them write the opinion. And it's not your opportunity to, make a stand and go over everything you've already discussed in your brief. It's the court's time.
Yeah. So we have a couple more minutes to go. One thing that, I've written a bit about is what I perceive to be an overuse of Rule 36 by the Federal Circuit. Now, we don't want to necessarily get into the relative merits of the court using Rule 36 or not. What I was wondering is you all who are really engaged in this area more and know the cases more, is there sort of are you able to predict when the Federal Circuit's going to do Rule 36? And if you are, how or why are you able to predict that? Are there certain arguments that if you make, or certain issues that you appeal, or certain things that you do, that it's just almost certainly likely that the Federal Circuit's going to pull out the Rule 36 stamp and affirm the PTAB? Is it something that the patent owner's doing, because usually it's the patent owner's doing or not doing, that walks them into a Rule 36?
Yeah, I would say one way a patent owner can walk themselves into Rule 36 is the shotgun throwing spaghetti at the wall approach. Raising procedural issues where they can't show prejudice. And if you've got too many issues, and it would take the Federal Circuit, a long time to write out why each one is meritless, even if they do believe those issues are meritless, I think you're likely to find yourself in Rule 36 land. By contrast, if you've got a very tight claim construction argument, and maybe that's your only issue, you might get a short non-prec even if, you end up losing. I think it's again, sort of to Angela's point, it's the court's time, right? And, you should be respectful of that in the way you are presenting arguments. Give them, some easy ways to decide in your favor, ideally, but, if you want to get an opinion out of it, you really need to give them a way to write an easy opinion for you.
Yeah, especially if all the appellant is doing is repeating arguments that were presented to the PTAB and addressed by the PTAB, and no, by God, the PTAB got it wrong, is what the appellant says, and they read a fairly tight PTAB final written decision, which often is the case, and you'll hear like, well, it looks like the PTAB did address that. I feel like that's prime Rule 36 material.
I think it's hard to predict. I think, generally you can get a sense for what type of case and what type of arguments might get 36, but it's also just as likely that they could get a, 4-page non-prec that's like, we've considered your arguments and they're not persuasive, which is not much different.
Right.
So, and I think it depends on a lot of things, obviously, like the arguments that were raised, if it's just a rehash. It also depends, I think, what other cases are being heard that day. If there's some like serious major issue in another case that's going to take a lot of the court's time on that panel to write that opinion, it might be a situation where your case gets a 36 where maybe it wouldn't have on a different day. So I think, I think there's a lot of factors that go into it. But yeah, throwing spaghetti at the wall is one way I think you might walk into one.
I like that idea. If you're a appellee at a PTAB case and the district court case in front of you is, something that's like really, kind of juicy, it's like that's a good place to be if you're the appellee to a PTAB case.
Yeah.
You don't think the court's going to be like, trying to write a precedential opinion that's not going to be criticized and overturned at the Supreme Court. So.
Right. Okay, awesome. Richard, go ahead, question.
Would you ever consider raising an issue on appeal that is a loser under current federal circuit law or even current Supreme Court law, but you want to preserve the issue to possibly raise it either on writ, seek a writ, or is that something that's not ever done?
Yeah, so I can talk to a little bit of that because I used to do a lot of constitutional litigation. I spent probably 2-3 years trying to get the AIA declared unconstitutional as applied to pre-AIA patents.
Oh, that was you?
Among others. It wasn't just me. But if you're going to do that, you need to be real candid about it. You need to you need to say, look, this is not the existing law. This is what I think the law should be based on these authorities. I recognize there are these other controlling authorities that are going against me. Acknowledge them, note that they exist, explain why, if you have any disagreement with their reasoning, and then just acknowledge that the Federal Circuit has to apply, its panel decisions until they're overturned en banc, in Supreme Court case law. I think you just have to be really, really candid about it. And recognize that the level of relief you're seeking may be another court that is not the Federal Circuit.
And the other way to do that is if it's the only issue you're going to raise, like, if you also want to raise like a 102, 103 argument, then this won't work. But if it's truly like one issue that you're trying to get forth for like en banc or further review, there's a procedure you can actually file a request for initial en banc hearing. So not going through the whole argument, getting a judgment, and then seeking on rehearing en banc. You can ask for initial hearing by the full court. And that's one way to very quickly, either get it up or down from the en banc federal circuit and then go to SCOTUS after that. It's done sometimes. It's pretty rare, though.
Yeah, it wouldn't be the only issue. I think it's sort of a side issue.
Mhm.
That we know it's a sort of a Hail Mary, but
Mhm.
you want to throw it in there to preserve it. So
Mhm.
just wondering if that would hurt our credibility or annoy the
Yeah, I think, I don't know that you're going to annoy them as long as you're upfront and acknowledge the controlling authority going the other direction and the fact the Federal Circuit has to apply the controlling law. But I agree, having a 102, 103 issue with that is often very important. Just because you don't want to come up here and just rail against the evils of the patent system and what they've done to your patent. It helps to have something that you give them an easier off ramp with the 102, 103 issue.
Yeah. Okay. Real rapid fire. Really rapid fire. Final thoughts. Tim.
So I worked a lot with the solicitor's office at the PTAB when I was at the patent office, and the DOJ, who's also does patent office litigation. And I think one thing they kind of drummed into me, and I try to apply this religiously, is credibility is so important, and it's important for repeat customers, especially because it's Federal Circuit's not a huge court, and it's so credibility is so important. And what that means is briefs sometimes get over lawyered during the process of editing, and there's a lot of editors. Go back and read it again, fresh eyes, and say, is every statement in here on all fours, or
Right.
am I over lawyering this? Because once you're over lawyering it, I feel like then they can't take what you're saying very
They can't trust
seriously.
you.
They can't trust you that you're giving them the honest story.
Great. Thanks a lot, Tim. Angela.
Credibility, obviously, but also just know the record like the back of your hand, because if you get to oral argument, these judges will have looked at every paragraph of expert testimony on the issue, and they will know it in and out, and they expect you to be able to be conversant with them as you're going through it. They will ask you to pull up the expert's testimony and let's talk through it together. So you better know the record better than they do, which is hard because they work very hard.
Okay, excellent. Good. And Kevin, the final word goes to you.
Make sure, in addition to knowing the record, you also know the law pretty well. Patent owners, if you're trying to argue that a legally deficient motivation to combine was presented in the petition, you should know that the Federal Circuit has largely expanded KSR in the last couple of years, really starting with the Intel versus XPP package fights decision in 2023. KSR is a lot more flexible than it used to be, and you need to keep that in mind as a patent owner. There are things that you may thought have not been legally cognizable motivations to combine that now are and have been blessed by the Federal Circuit, so keep that in mind.
Great. Good advice. Well, thank you all for a wonderful conversation.
Thank you.